Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee is dismissed for reasons relating to pregnancy. When is a dismissal automatically unfair? Now, to answer this question, I'll be referring to the matter of Brandt versus Coinrock Wines. And as always, let's start by looking at the facts of the matter. In this case, Ms. Brandt was employed by the employer as a financial manager. She was earning a gross salary of 50,000 Rand per month at the time of her dismissal, and she was dismissed on the 30th of November 2020. Now, Ms. Brandt had received IVF treatment as a single person in January 2019, and became pregnant with a due date of 11 June 2020. Ms. Brandt informed the CEO of the employer on 3 January 2020 of her pregnancy, and she told him that she would work until the 31st of May 2020. Unfortunately, there were complications with her pregnancy. She was admitted to hospital to be monitored, and on the 2nd of May, the baby was born. Ms. Brandt had scheduled to do a handover of her work to her assistant on the 14th of May, but obviously was unable to do so. Ms. Brandt took her laptop to the hospital and was discharged on the 12th of June 2020 with her baby, and had her first handover meeting with her assistant 3 days later, whilst on maternity leave. The employee informed the CEO that she and the baby had to be admitted to hospital again for a few days, and her maternity leave indicated that it would be from 1 June 2020, as I've said, to the 30th of September 2020. However, Ms. Brandt advised the CEO that she would revise her situation at the end of August and might consider to start working half-day from September. On the 2nd of July, the CEO had finally returned unanswered calls that Ms. Brandt made to him. There was a 27-minute conversation between them. The employee said that he was screaming and yelling on the call. The employee said that the CEO told her that he could not go on like this and that he needs a financial manager, and that he could not understand why the employee could not be available for work calls but could do 2 photo shoots with her baby. It's important to note that this was during July when she was still on maternity leave. The employee said that when she returned to the office on the 1st of October 2020, she found the vibe awkward in her office. She sent the CEO a message to ask for a laptop, and when he arrived, he asked her to come to the boardroom. The CEO told her that he thought he could not afford her and mentioned that he had still not talked to HR about this. He said that he didn't want her at the office because she would confuse staff with her presence and there was no work for her. The employee also said that she asked him to tell her what he said in writing so that she was not absent without approval. A meeting was held with HR on the Monday. During this meeting, the employee was told that a decision had been made whether there should be a mutual separation agreement or a Section 189 process. But on the day of the meeting, she received a notice of retrenchment. The employee said that in this meeting, she said, or the letter provided was not a mutual settlement agreement, and that the notice also referred to the statutory minimum for retrenchment pay. The employee agreed that another employee had taken on additional functions when she was on maternity leave. The employee insisted that the CEO's attitude to her changed when she said that she was taking maternity leave. She stated that if he had restructured the department in August, why had they not launched the consultation process sooner? The employee accepted there was a consultation process, but not that any alternatives were listed for her or that any information on the employer's financials had been provided as she had asked. Following a dismissal, Ms. Brandt approached the Labour Court for relief, alleging that a dismissal was automatically unfair for reasons relating to her pregnancy. Now, initially or at first, the Labour Court referred to Section 187 of the Labour Relations Act and confirmed that it provides in material part that a dismissal is automatically unfair if the employer, in dismissing the employee, acts contrary to Section 5 of the Labour Relations Act, or if the reason for the dismissal is the employee's pregnancy, intended pregnancy, or any reason related to her pregnancy. The court held that no substantive evidence was produced by the CEO to show that her retrenchment was necessary for operational requirements. Safe to say that minus her salary, a cost cutting would be achieved. No evidence was tendered as to how there would be a cost saving to the respondent once a consultant attended to functions formerly performed by the employee and 2 extra persons were seconded to do accounting administration. The court held that the employee had done her best in the most difficult of circumstances while suffering from high blood pressure in hospital before the birth and attending to a child who was in ICU after the birth in hospital to perform the essential functions of her job. She had not had time to do a full handover of her functions because her pregnancy did not go the full term. The fact that she was not available during all working hours between 12 June, when her baby was discharged from hospital, and the writing of a letter on the 25th of June, when she set out how she would like to organize her maternity leave, that was no basis for law for her employment to be under threat. The court confirmed that Ms. Brandt was required to produce evidence which is sufficient to raise a credible possibility that an automatically unfair dismissal has taken place. The court further confirmed that once the employee has proven that an automatically unfair dismissal has taken place, the employer must prove the contrary. In other words, the employer must produce evidence to show that the reason for the dismissal was not related to Mrs. Brandt's pregnancy. Now, the court held that Ms. Brandt had met her evidential burden in this case, and that the employer has not met the onus of showing that genuine operational requirements were the real reason for the termination of the employee's employment. The court said that the CEO's own evidence threw light on the relationship or the relation between the dismissal and the employee's pregnancy. The court said that the fact that the employee on advice participated in the consultations of the 189 process and tried to save her livelihood by doing so is neither here nor there. The court therefore concluded that the essential facts of this case, taking into account the witness testimony, leads to an inescapable conclusion that the termination of the employee's employment was indeed related to her pregnancy. So the court therefore found that the dismissal of the employee was automatically unfair. The employer was to pay the employee compensation in an amount equivalent to 16 months of her salary at the time of her dismissal, being 800,000 Rand. Furthermore, the employer was to pay the costs of the referral. Now, colleagues, this case serves as a cautionary signal to employers, indicating that they may incur substantial compensation awards and potential cost orders if they neglect to uphold the maternity leave rights of their employees. It is crucial for employers to exercise care in justifying dismissals, avoiding the use of pregnancy as grounds unless there are genuine operational reasons for such actions. Maternity leave is designed to safeguard employees, ensuring their equal status in the workplace and protecting them from prejudice or unfair treatment. When faced with disputes of this nature, seeking legal advice is always advisable. That then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we'd love to hear from you. As I've mentioned many times, you can find us on social media or you can email us at info@massconsulting.co.za. I'll see you in 2 weeks' time. Bye-bye.